Hello guys, welcome to LawPutra YouTube channel. I am Bharma here. Today we are gonna discussing about the topic procedure of retrenchment. Before going into the procedure of retrenchment, let's know the meaning of retrenchment. Retrenchment refers to a situation where employer removes his employees to increase his profits and decrease his losses. It is a situation which we see in most of the companies where higher authority removes his lower authority to increase profits and decrease his losses. Section 2 of Industrial Dispute Act talks about retrenchment. Section 2 of Industrial Dispute Act talks about retrenchment. Retrenchment refers to the termination of a workman for any reason except in the form of punishment, where punishment shouldn't be given under retrenchment, and it is an imposition of disciplinary action. In furtherance, it can be simply said as imposition of disciplinary action. Retrenchment doesn't include these four conditions, where voluntary retirement of a workman, retirement upon reaching the age of superannuation, mostly 60 years is the common age of retirement, which this doesn't include retrenchment, and thirdly, removal of workman on a continuous ill health, where a workman suffers from a continuous ill health from a long time. It doesn't include under retrenchment. It doesn't include under removal of retrenchment. And fourthly, removal of workman because of employment contract is terminated or non-renewed after its expiry, where contract is fulfilled. Now let's see the condition of retrenchment. Section 25F of Industrial Dispute Act 1947 talks about condition of retrenchment or condition precedent to retrenchment. First point discusses about the employer must give an 1 month prior notice or written notice to the workman that includes reasons for retrenchment. That means they should give a written notice which includes reasons for retrenchment. Workman must be paid wages for the period of notice. They must give wages for the period which given notice. Second point, the employer at the time of retrenchment must pay the workman the compensation. The compensation must be given to the employer, which is equal to the average pay of 15 days for each year of a continuous service provided by such workman. Third point, the notice regarding retrenchment must be served to the appropriate government as well. It should be served to the appropriate government as well. These are the conditions which are discussed under 25F of Industrial Dispute Act for retrenchment. Now, let's move into our main topic, procedure of retrenchment. Section 25G of Industrial Dispute Act 1947 talks about procedure of retrenchment. Remember this, Section 25G of Industrial Dispute Act 1947 talks about procedure of retrenchment. The principle LIFO, last in first out, is applied in the procedure of retrenchment. The principle LIFO, last in first out, is applied in the procedure of retrenchment. It is important to note that under Section 25N of Industrial Dispute Act 1947, where employer is required to make application along with the reasons intended to the retrenchment of employee and to take a seeking prior permission from the state government to retrench the employee. Hence, a simple termination as per the contract of employment can be backfired if the termination is challenged. Let's perfectly discuss about procedure of retrenchment, where any workman in an industrial establishment who is a citizen of India is to be retrenched and he belongs to a particular category of a workman in that establishment. In the absence of any agreement between the employer and the workman in this behalf, the employer should ordinarily retrench the workman who was the last person to be employed in that category, unless for the reasons to be retrenched or recorded by the employer, where the last person is to be retrenched by the LIFO principle, last in the first out principle, the last employed person shall be retrenched. There are 4 steps, namely consultation, written notice, criteria for selection and written notice to termination. These are the 4 major procedures or steps under the procedure of retrenchment. Let's briefly discuss these points. First one, consultation. The employer must consult the employees who are likely to be affected by the retrenchment. The employer must consult to all his employees who are affected by the retrenchment and the registered trade union. They should also consult to the registered trade union. The employer must respond to the consulting employees' representation. The employer is wholly responsible to the employees' representation. If the employer disagrees with the consulting employees, it must state the reason for disagreement. They should also state the reasons for disagreement. After consultation process had commenced, the employees may take or make its decision to retrench. The employer must select the employees to the dismissed based on selection criteria. As per the selection criteria only, the employer should retrench his employees. Now, let's go into the second point, written notice. The employer must issue a written notice to the employers. It is must and should that written notice should be given to the employees by the employer in the process of retrenchment. There are reasons for also retrenchment. Let's discuss it now. The first one are alternative considerations and reason why they are rejected. They should also state the reasons why they are rejected. And second point, the number of employees likely to be affected. In that written notice, they also should state that how many number of employees should be affected in the retrenchment. Third point, proposed method of selection. In the written notice, they should also write down that the proposed method for selection of retrenchment of employees. Fourth point, severance pay. Fifth point, assistance that employers will be offering. They should also write down the situations or assistance that employer will be offering. Sixth point, possibility of future re-employment. In the written notice, they should also include that if there are any chances of re-employment of the retrenched employee. Third step, criteria for selection. Employer may select employees to be retrenched according to the criteria they have agreed upon. Basically, LIFO principle, last in the first half principle, is applied in this point, criteria for selection. The last in the first half means the employee who is lastly employed in the organization is the one who is going to be first out or retrenched. In third point of which is criteria for selection. Fourth point, written notice of termination. A written notice is given to all the affected employees. There are the affected employees under retrenchment. All the people should also get the written notice under retrenchment or procedure of retrenchment. There are basically 4 points which are consultation, criteria for selection, written notice and written notice of termination. These are the main points under the procedure of retrenchment. Now, let's discuss about the famous case laws in the retrenchment. Firstly, Bairam Pestonji Gariwala versus Union of India. It is a main case under retrenchment. Second one, State Bank of India versus N. Sundarmuni. It is also a famous case law under retrenchment. Third one, G. Jagadishwar Reddy versus Railways, Guntkal Division. Fourth case is Delhi Cloth and General Mills versus Union of India. These are the famous case laws which comes under retrenchment. In conclusion, we can say that in order to survive in the market, companies are required to accurate and expeditious decisions. Terminating the employees and workers by the means of retrenchment may be beneficial to the companies as they follow certain protocols to make sure that the employees and the workers are not subjected to unfair conditions. They follow certain protocols and unfair conditions are not followed, which means it is also sometimes beneficial to the company and growth of the companies. This is about the procedure of retrenchment. If you like the video, please do like, share and subscribe to LawPutra YouTube channel. If you have any queries, please leave it in the comment section. Don't forget to hit the bell icon. Please do like, share and subscribe to LawPutra YouTube channel. Thank you.